Hey, everybody, this is Josh for another episode of the Canadian Immigration Pros podcast. I am your host, Canadian immigration lawyer and CEO here at Visto.ai. Very happy to be joined today by Rema and Rebecca from R&R Law. Rema, Rebecca, thank you so much for coming on the show today.
Thank you, Josh, for inviting
Thank
us
you.
to be here today. It's truly our pleasure. My name is Rima. Me and Rebecca, we are the co-founders at R&R Law, a Toronto-based firm where we offer all types of immigration services with a focus on business immigration. We both have over 5 years of experience in the legal field and 3 years in immigration law. Thank you for
Awesome.
having us.
Yeah, no, it's my pleasure to have you on. I'm excited to cover a couple different topics, some of which we've kind of talked a little bit on the CIP podcast before, some of which we haven't done a deep dive yet. So I'm pretty excited.
Right.
We're going to talk a little bit about the Francophone Mobility Program. We're going to talk about GTS, Global Talent Stream, for those who haven't heard of it. So LMIs related to tech workers. We'll talk a little
Mhm.
bit about judicial review as well. So we're going to cover a couple different interesting topics, in my opinion. Let's start with Francophone mobility. I've had a few lawyers on to talk about Quebec immigration, which, as we know, can be a whole other world in and of its own. And some people are surprised. In fact, I remember when I heard first about the Francophone mobility program that it existed because I thought, all French stuff was kind of focused in Quebec. But anyways,
Right.
maybe just to kick us off, can you guys describe what is first and foremost the Francophone mobility program? And kind of how did it come to be?
Sure. So I'd like to start with a little bit of a brief overview about the history and the purpose of the program. So this program was launched about 7 years ago with the whole intent to increase French-speaking communities outside of Quebec. And so as we've seen, and especially in recent months and years, Francophone immigration continues to be a key priority for the government as they want to promote bilingualism and added cultural perspectives with a special emphasis on safeguarding French culture and language, particularly outside of the province of Quebec. And this program basically makes the work permit process a lot easier for French speaking foreign nationals because they have far less eligibility requirements than other programs. And it does fall under the International Mobility Program, meaning that employers do not have to obtain an LMIA to hire these foreign workers.
Right, and I think the key part there is the LMI exemption, right? Because as many of us know, excuse me, the LMI process is just quite frankly a pain in the ass and an extra step and typically,
Yeah.
long processing times that employers would rather not have to go through and not have to pay for if they're applying for an LMI that does have a fee associated, which many of them do. So not having to go through the LMI process, and can you just clarify, Rebecca, like what are the key, as far as I know, it's basically if you can speak French and you're going somewhere outside of Quebec, right? So ironically, in my opinion, you're a French speaker, but you're not working in Quebec, which, as you said, is to promote the bilingualism of Canada, or the hope for bilingualism.
Yes,
Is that a word? Bilingualism? I don't know.
it is.
Maybe
Yeah.
I just create. Okay, awesome. Yeah, can you talk specifically about the eligibility requirements? And then I think you mentioned as well that there's some recent changes to the program. So
Yeah.
maybe anything that has changed of note recently.
Sure, I'll get into both. So, in June of last year, the program was actually extended for 2 years, and they did make some updates to the eligibility requirements. So, let's start with what hasn't changed. So, applicants still need to plan to live and work in any province or territory outside of Quebec. And as far as what has changed is the language and the job offer requirements. So, for the language requirements, previously applicants had to convince IRCC that their language of daily use was French and that their French skills are equal to an intermediate level. So think level 7 against CLB, or it's called NCLC. Whereas now applicants are only expected to communicate in French at a moderate level, so CLB 5 as opposed to CLB 7. And this can be proven by writing a French language test or showing documents that show education documents in French. And as well, if you're at the port of entry, if the immigration officers aren't convinced that you can speak French, they might do an oral assessment. So,
Hmm.
going on to the job offer requirements now. Previously, applicants needed a job offer in a high skilled occupation. So that's tier 0, 1, 2, or 3. But now job offers can be in any tier category with the only exception being agricultural occupations in tier 4 or 5. So overall, we're seeing that these changes are just making the process more accessible and inclusive for all prospective applicants.
Right, it's very interesting. So basically they've reduced the requirement for language and they've opened it up to way more, pretty much any occupation other than agriculture, as you mentioned. Do you have any idea as to why? Is it just the government's like doubling down on wanting to bring in French speakers? And then the other question I had is, do you have to include a French language exam, or is it just like an option to kind of bolster your file?
So to answer your first question, yes, the government is, you know, placing a large emphasis on Francophone migration. We're seeing that even in the express entry draws. The last draw was, I think, on Feb 1st for the French specific category, and the cutoff was 365. I know that's a little bit of a side topic, but that's what the government is focusing on right now. And as far as the language test, we don't usually include it if the applicant, for example, is from France. It's very clear, and a lot of our times the applicants are coming to the port of entry as well. We just tell them just speak French to the immigration officer, and then they can assess at that point, okay, this person is a native French speaker, and so they're clearly meeting the requirements. But if it's an online application, depending on the type of applicant, if they have written a test, we usually include it as a supporting document.
Got it. So interesting. So it's not a hard requirement per se, and I guess it kind of sounds like a case by case basis.
That's
What
correct.
country are they coming from,
Yeah.
et cetera, et cetera. So that's super interesting. So probably most employers in Canada don't know about this, would be my guess, having, not recently, but when I was practicing, having worked with many, many employers. What do you think Canadian companies, in this case, I guess located outside of Quebec, because if you're inside Quebec, you don't qualify for this. But what do you think some of the key pieces of information that Canadian employers and maybe employees, maybe there's some people listening to this podcast and they're native French speakers living outside Canada interested in coming to Canada. What do you think both sides of that coin should maybe know about or keep top of mind?
Sure, there's some great perks for both employers and applicants within this program. So I'll just break down a few of the key ones. So for applicants, aside from the more lenient requirements that we mentioned earlier, and unlike other programs such as, for example, International Experience Class, this program's open to applicants of any nationality. There's no age limit. Your dependent family members can accompany you. And as far as the benefits for employers, like we mentioned before, there's no need for an LMIA, meaning that there's no requirement to advertise the position in advance, something you'd have to undergo under most LMIA categories. This also means lower government fees for the employer. It's only $230 to register the offer of employment versus $1,000 for LMIA. Another great one is that there's no obligation for a median wage as long as the wages are reasonable for the position and is above the minimum
Hmm.
wage of the province. The last couple of things is that the language of employment doesn't need to be in French. And if visa exempt, like nationals from France, they can apply at the airport or port of entry using their ETA, and it makes the process a lot quicker than having to apply online, which can take several weeks to months, depending on which visa office your application is being processed.
Right. I mean, yeah, that's a great summary. And if I could even summarize further, is like if you can find French speaking people around the world, you might be able to bring them to Canada really quick without needing an LMIA and potentially having them hop on a plane tomorrow and apply at the port of entry, like you said, which for those who don't know, port of entry being like when you land in Canada by plane or if you're driving from the States or whatever. So huge benefit. My last question on this topic, Rebecca, and maybe a little bit more random, is why do you think, like, as you mentioned, they recently did a big express entry draw, right? Like they had done a couple general draws in like the 1,000, 1,500 range. Out of nowhere, they come at us with a 7,000 person French speaking draw. Obviously, the federal government, as you mentioned, is like really pushing French. Do you know why? Like, I don't know. I get it. Canada's bilingual. This is more like opinionated. I get it. Canada's bilingual and they really want to push for French. but I've lived in Toronto and Ottawa my whole life. I don't hear anybody speaking French. So I
Right.
don't know. Are they just really trying to push it? Are there actually like employment needs from French speaking companies? I don't know. Do you have any ideas?
No, in the same boat as you, and you're so right about them pushing it because, we check the IRCC, the website, the news releases on a daily basis, and I've been noticing that every couple of weeks they're sort of putting out, some information about their focus on Francophone immigration, all the policies and action plans and targets they're achieving. Yeah, that's a good question. I can't think of anything besides really like, safeguarding the French culture and bilingualism. I mean, it's great for applicants all around the world that have some French speaking ability. We kind of mention it on all the calls that we have with clients. Do you know French? Because it's the best way for them to enter Canada at the moment,
Yeah, well, what I
or one
don't
of the
get
best
is it's
ways.
great for French speakers anywhere. It's not great for all the temporary residents inside Canada that are going to lose their status because they can't come through express entry, because you know what I mean. So, anyways,
Yeah.
maybe that's a whole other conversation, but certainly interesting and important for employers and employees to know about. So that's great. I'd love to shift focus over to GTS. GTS has a soft spot in my heart because as I think the two of you know, that's what, when I was practicing, that was most of my business. And so I'm excited to talk about it because I haven't done it in a few years, and kind of curious to hear how things are going, in that part of the world, if anything's changed, what hasn't changed. So Rima, can you give
Yeah.
us a little introduction? First of all, what the heck is GTS for those people who don't know, and what are the basics of the program?
Well, for those who do not know, GTS, it's a global talent stream where employers in Canada who needs to hire temporary foreign workers that are highly skilled can apply through this stream. This type of stream can be applied online through the LMIA online portal. And once you receive a positive LMIA through this stream, it will be valid for 12 months from the date of issue. Also, employers submitting the LMIA application, they may request an employment duration for up to 3 years.
Got it. And one of the reasons why I liked it was, well, two reasons, I guess. Number one is the recruit. I'm assuming it still exists. The exemption from the recruitment requirement, right, for the
Yes,
LMIA,
yes,
and then the
definitely.
high focus in tech, just because I like the tech industry. And so, can you talk a little bit about like what companies or which occupations that the program might be best for?
So basically, most of the companies that can, our employers that can apply under this stream are tech focused company with the specific NOC codes mentioned on the ESDC's website for this type of application.
Got it. So, and for those who don't know, I just like to over summarize because maybe we have some listeners who, this is their first Canadian immigration podcast, maybe. A knock code, meaning what used to be a 4 is now a 5-digit number that kind of coincides with job titles, right? So there's a knock code
Mhm.
like for GTS, there's one for
Yes.
software engineer, there's one for engineer manager, et cetera, et cetera. Do you see any themes, Rima, in terms of like what are the most popular, like if there's a company listening to us right now and they're
Hmm.
like, "Oh, this might be a good fit for me." Any
Yeah.
popular titles that you see a lot of companies using GTS for?
Yes, definitely. So, based on my experience, the most two popular positions, so where employers hire under, is software engineers or software developers. These two positions are really in the air all the time, and employer are really hiring these temporary foreign workers under this job title.
Got it. Yeah, absolutely. And especially if the tech industry kind of comes back to what it was, this was pretty popular to build out tech companies, tech teams, and all that kind of stuff. Let's talk about probably the most unique part of that application, which is the LMBP. So one of the huge benefits of GTS is you're exempt from recruitment, which is great. You don't have to try and recruit for 30 days and show proof because the government has agreed, hey,
Yes.
we realize there's such a need for tech workers. You don't have to do recruitment. But On the other hand, you have
You
this
have,
document called the LMBP. Can you talk a
yeah.
little bit? What does the LMBP stand for? What does it mean? Is it difficult? What's that process like for employers?
Well, it's so when an employer wants to hire a temporary foreign worker, the employer need to provide commitments to ESDC. These commitments might some of these commitments might be mandatory. Some of them are complementary. However, these commitments can be by increasing and training the Canadians and permanent residents, or it can be by job creation or knowledge transfer or enhancing the company performance. It's not a very difficult process. However, the employer should be in compliant with all these commitments when submitting the LMA application. One thing that I would like to emphasize that the GTS stream encourages employers to commit to increasing diversity in the workplace, and this specifically targets the underrepresented group.
Right. So basically in return for expedited processing, not having to recruit, stuff like that, what they're asking for is the company to commit to some of these activities to, benefit the Canadian labor force, like you said, increase diversity, training, all
Yes,
that kind of stuff. And I would agree from my experience, like the first application, maybe it takes a little bit of more work because you got to look at the different activities and decide
true.
which one's best. But, not rocket science. And in my opinion, certainly better than spending 30 days trying to recruit, right? And tracking everything and
Definitely. Yeah.
all that kind of stuff. Can you talk a little bit about payment or wages? Like what can Canadian employers expect? What are the requirements, especially in tech, right? Where salary is important, right? Especially
Yeah.
when you're looking at maybe opening offices in different parts of the country, or you're thinking about an office in Canada versus other countries around the world. How do employers have to think about wages?
So wages that are offered to temporary foreign workers should match the regional median hourly wage posted on the job bank related to the specific NOC code that temporary foreign worker is hired under. Also, the wage that should be within the wage range that the employer is paying his current employees who are hired under the same job, the same work location, same with the same skills and years of experience.
Right. So either if the company's already employing temporary foreign workers that are tech workers with the same knock code or same title, within that range, otherwise at the very least meeting, as you said, the median wage. For those who don't know, basically the government sets what's called the median wage, which is like the minimum wage that you must pay temporary foreign workers based on what region of the country and based on what their knock code is as well. Again, something that probably sounds a little bit more confusing than it really is, right, Rima? And or if you're working with a professional like yourself, I'm assuming you guys would do a lot of the work to help the employer navigate those requirements.
True. Yes, we do.
Awesome. I kind of lobbed that one in because I think I knew the answer. But anyways, awesome. I mean, I think it's a great program. What do you think? Like, have you seen any changes in the last year or two? I don't know. I haven't kept that up to date. I knew the program inside and out because I did it for years and
Yeah.
years and years. Haven't done it for a few years now. Have there been
Yeah.
any major changes? Are
Yes.
the processing times still really good too?
Yeah. Processing times are still the same, like up to 2 weeks. However, in November 2023, the wages were increased on job bank. So employers, whoever submitted their LMI application during this time, employers should modify the wage and just match it to whatever the job bank wage is at that point.
Got it.
Yeah.
What do you think? Do you like the program? Is it here to stay? Is it going to be here for a long time?
Well,
What
it's
do
a really a great program, right? It's efficient with time. The temporary foreign workers, especially in the tech field, like they are benefiting from this type of program.
Awesome. Yeah, I used to love it. I keep saying I think Canada actually has great programs right now, and one of the problems, I mean, maybe either of the two of you can let me know if you agree. I think one of the big problems since COVID is they've just been creating too many programs, right? Like I think
True.
GTS, Express Entry, IMP, study permit. Well, study permit needs a few more fixes. But anyways, I think Canada has like a really good skeleton of programs, and they're just creating too much now. Like there's too many exemptions and special this and new that, and it's just confusing everything and processing times go down, So I don't know. I think they should go back to the basics and bring all the processing times down, keep the systems really simple and manageable for these companies. I don't know. Do you guys agree? Do you disagree? Am I crazy?
No, like, yeah, it makes sense
I
because
agree.
lately there are a lot of temporary policies in, and we really can't keep up with all these changes.
It's hard enough
I
for
mean,
the
I understand
practitioners.
some of them, right? Like especially when you have the situation in Ukraine. You know what I mean? Like when there's stuff like that, sure, I get it, right? Special work permit programs and stuff like that. But now there's pretty much like a new exemption or special program for everything under the sun, right?
True.
Whereas, in my opinion, if you just made the old programs fast, or if you just made LMIs quick and easy for employers, you wouldn't need half these special programs, right? In my opinion. So, anyways, let's move on because a lot of that confusion causes refusals, delays, all that kind of stuff. I never did work in judicial reviews, but I'm hearing about them more and more, sadly, these days, because more and more people are having to turn to them, right? Unfortunately. We have covered JRs a little bit in the past, so if you are interested in JRs, number one, keep listening to this episode. And number two, I forget which episode it was, but I did cover JRs in another episode as well. I'll link to it in the show notes. But can we cover number one again for those who may be listening in for the first time? What does JR even stand for, and what is it?
So I'll take that one. So when you receive a refusal from IRCC on applications like study permits, work permits, express entry applications, sponsorships, or any final decisions, you have the option to challenge the decision through the courts using a process called JR. So when you apply for JR, you're essentially asking the federal court to review a decision that you believe was unfair, unreasonable, or unlawful. So, this could include situations where the officer didn't properly consider or ignored certain supporting documents, or where the decision making process itself was unfair. So, the whole purpose of it is to have the judge reverse or cancel the refusal and then send it back for reevaluation or reconsideration by a new IRCC officer. And something important I'd like to highlight is that it is not an appeal and it's not an opportunity to re argue the case. The judge can only review the decision and set it aside for redetermination. They can't substitute their own decision over that of the immigration officer. I feel like a lot of applicants get confused with that idea.
Yeah, and I mean, even I was kind of confused the first time I realized that there actually is no appeal process, right? Well, not no formal appeal process with IRCC, right? You could ask for something like a reconsideration request, but that's really, not very formal. And as you mentioned with a JR, the court's not deciding, hey, your application should be approved or rejected. They're deciding if it should be sent back to be then reconsidered. I think by so if you win the JR and it goes back to IRCC, is it a brand new agent that gets that file? I'm
Yeah.
assuming they don't just
Yes,
send it
it is.
back to the same agent, right?
No.
So
It's a brand
how
new
should a
officer. Yeah.
yeah, I mean that makes sense for obvious reasons. So how should a client think about this? I submit let's say like a TRV or a study permit because those are probably the highest risk for refusal, and you get a refusal, right? For I don't know, whatever reason. What are the different options, and what do you advise clients? Like when is JR a good option versus what other options might be available?
Yeah, so basically, once a refusal is received, the client has mainly three options. It's either going with a reconsideration request, as you mentioned previously, which is going to take from 2 to 3 months for IRCC to respond, or by applying for GCMS notes, and it might take months or maybe more, as we're seeing recently. And then we can just reapply for a new brand application and avoid the same mistakes that were filed with the first application. And the third option is applying for a judicial review, which might take from 4 to 6 months, depending on the complexity of the matter. However, the client should keep in mind that judicial review cases are time sensitive, and the applicant should apply in 15 days after receiving the decision if the refusal was from inside Canada, or 30 days if the decision was received from outside of Canada.
Right.
Yeah.
So you gotta love IRCC, right? Because none of those options are fast, right? You get a refusal, and what you're saying is basically order GCMS notes. So for those who don't know, are basically more detailed notes from the processing agent on why they might have refused your application. Why do people ask for GCMS notes? Because the refusal letters are pretty basic and in most cases useless, right? It's like a standard one sentence. So option number
Exactly.
1, order GCMS notes, probably going to take you a month or two. Option number 2, try a reconsideration request, like you said, probably takes 1, 2, 3 months to get a response. Number 3, JR, but you have to submit the JR within 15 or 30 days.
Yeah.
So it almost sounds like one or the other, right? Like if you go the first two, your option to JR might expire, right?
Yes,
So
exactly.
what would you say, like, when is a good case that you would recommend somebody to maybe JR right away versus try one or both of the other two first, or maybe just not JR at all and be like, hey, we're going to do GCMS reconsideration and maybe reapply?
Well, it always depends on the case, right? If there's like a procedural fairness, or there's the refusal was faced because the IRCC officer didn't really consider a specific document. Here where it comes like, yeah, it's a good case for judicial review, right? So what we do from our end, we assess the purpose of the refusal. And we always advise the client, like, hey, go ahead and submit the reconsideration request. It costs nothing. And your case is a very good fit for judicial review case. Go ahead and submit the application and see how it goes, you know? So yeah, it's specifically for judicial review cases because it's really time sensitive. And if the case has good grounds, like we always push the client to move forward.
Interesting. Yeah, I feel like it's probably gotten more popular and may only get more popular in the future as we're getting more and more refusals. The reasons for refusals seem to be more vague than ever. You know, IRCC resources seem to be limited, so it's hard to get responses. It's hard to get GCMS notes quickly, right?
Mm-hmm.
It's sad, right? It it almost makes me think like we shouldn't even need JRs. If the refusal letters were just better and if the decision making was just better, in a
Exactly.
perfect world you wouldn't need them, right?
True.
So let's say somebody does decide to go down that JR route. What does that look like? What are the steps involved? Is this an expensive process? Is this a long process?
Well, this process takes from 4 to 6 months. The steps, it's around 8 steps. It has 3 phases. It starts with filing the application for leave. And as mentioned, you have only 15 days or 30 days, depending on the decision from where it's received, inside or outside of Canada. In the application, you will just list the what you're going to argue and the details, the file number, UCI number. And then you have to reach the stage. There are other steps, it's such as filing the service of application for leave, and then the respondent should submit or file the notice of appearance. And the fourth step is obtaining the tribunal written reasons. It's the officer's written reasons on why the application was refused. This is the fourth step. And actually, this is a major step where the lawyer should assess, should I move forward with filing this type of application or case, or shall I stop and go for settlement?
So you mean the lawyer from the government
No,
in
no,
terms of the
like
settlement,
like
or
us, like as lawyers, when we're working on a type of application, let's say what we received the written reasons from the officers from the tribunal about why the refusal is in place. Here, where we should assess, shall we move forward with the case or settle the case with the tribunal?
right? But does settle basically mean like drop the case? Because
So
What's there to
settlement,
settle?
yeah. So it depends. Sometimes the tribunal will be like, okay, so yes, the IRCC officer did a mistake. This is the best option that we can provide you with your case. Would you like to go to settlement and agree with this solution or not?
Okay. So the government kind of might put something to you and say, here, instead of all of us taking more time and going to court and arguing this out, here's an alternative solution or
Yeah,
a,
and
a
you can
quick
also
quick
request
decision.
for it. You can request for settlement as well. If
Okay.
the tribunal agrees that they did a mistake from their end.
Okay. So I'm assuming this most of the settlements, quote unquote, is sending it back to IRCC? Like, are there any
Yes.
other options or outcomes other than obviously like, hey, no, this was rejected for the right reasons. See you later.
Yep. It basically means that in most cases when it's settled, your JR application, it means it's been successful and your file is being now returned back to IRCC for redetermination before it proceeds to a hearing stage.
Got it. Are those pretty much just the two outcomes? Like either they hold the decision for refusal or they send it back to IRCC? There's like not really anything in between, right?
Yes, that's
Got it.
correct. Yeah.
Which makes sense. What would you say is a probability of success? Like, do these things, do you win them a lot? Or what can, potential obviously a little bit case by case, like with anything. But assuming you have like a half decent reason to be JRing in the first place, is it a strong chance? What do you typically recommend to your
Yes.
clients?
So, an interesting statistic actually is that only 20% of immigration applications are granted leave by the federal court. But this shouldn't be seen as something disappointing because, as we mentioned, there is potential for the case to be settled before reaching this stage. And the reason that IRCC might be inclined to settle is because opposing a judicial review takes a lot of time and resources. Additionally, if your JR is successful, it could set a precedent for other cases and compel IRCC to change their procedures for future refusals. So, for example, if a judge finds that IRCC's assessment of a program was unjustified, it could prompt IRCC to revise their evaluation process for many applications. So it's actually in their interest to settle as well.
Right. So when you say 20, you mean 20% that go all the way to court?
That's correct. Yes.
Okay. So just to clarify for me and maybe some listeners, so a good chunk of them probably settle before court, right?
Yes,
But of the
exactly.
ones that do go to court, 1 in 5 of them are successful, is what you're saying?
No,
20%?
it's only 20% that actually get to have the hearing because majority of them are either
Okay.
rejected or it's not successful. They didn't have a good case for JR. Yeah.
Okay. So that's almost like a good thing in a way, right? Because
Yes.
waiting for court and then paying a lawyer to go to
Yes.
court for you takes time and is expensive. So you're saying 80% of these are decided before court,
Hmm.
which is probably a good thing. Even if it's bad news, at least you get the decision quicker and you don't have to pay for it. And or if it's a decision in your favor, you don't have to wait the 4, 5, 8 months, however, and you probably like how do lawyers charge in stages, I guess? Like if they don't
Yeah.
have to go to court, it's probably less money, right?
Yeah.
Out of the
Yeah.
out of the pocket of the client.
Yeah. It's like 3 stages. So from the time you file the application for leave until you receive the officer's written reasons on the refusal, this is the first stage where you have to charge for it. If the
Well, you don't
case,
have to if if you don't need money to pay your bills, right? But yeah, I know what you're saying. I'm
and
assuming most I don't know. I don't even know the business side of JRs. Are you saying like most firms they'll kind of charge it in
yeah,
phases like yeah.
most of them do that, like phases.
Mhm.
If the case was worth it to proceed, then it comes the second stage where you perfect your application per leave and submit it. And then the respondent also submit their argument as well. Both of these parties during this period has 30 days. And this is the second stage where you have to charge the client again.
You want
But
to.
if you want to, if you have bills to pay. And the third stage would be when you have to reply to the respondent in 10 days. And then when it comes to the disposition of the application for leave, it's either the judge will dismiss the case or grant you the leave. This is the final stage where you have to ask the client to pay.
Got it. Okay, that's really interesting. And part of the reason why, I run this show is to hopefully educate aspiring immigrants who might not even know that this is an option, right? And or, when it might be a good case. Do you have one or two examples? Like what's a good example of a situation of an aspiring immigrant or applicant, whichever part of the process they're at, should make the decision to JR?
Yeah, so one of the cases, it was filed for judicial review for incompleteness of the documentation. So basically, this case is Core versus Canada, where it was a TR to PR application when it was opened during, I think, 2 years ago. So basically, the applicant, when she was uploading her documents, she overlooked uploading her educational documents and realized the mistake after submitting her application to IRCC. However, once she realized that she missed uploading this document, she went ahead, submitted a web form to IRCC just to rectify this mistake. But still, the application got rejected for incompleteness. So at that point, she was not able even to resubmit again because this type of application just closed, right? So she sought judicial review, and the court granted her a leave, setting aside the decision, and the case was assigned to a different decision maker. It's because the officer didn't consider the web form that was submitted right away after submitting the application, and that the web form technically included all the educational documents that were missing from the initial application.
Got it. So basically, okay, that's interesting. And for those who don't know, TR to PR was another special exemption, one of the few during COVID, allowing temporary residents to apply for PR. But like you said, Rima, it shut down after, I don't remember, I think it was open, well, it filled up pretty fast, right?
Yeah.
So by the time this person's application was refused, the program was over, so they couldn't even reapply if they wanted to through that program. And so because the agent didn't even consider the web form, I wonder, is that just like a mistake by the agent? Or is it just like, I mean, this isn't, you probably don't, maybe you don't know the answer, but like, why didn't the agent just look at the documents from the web form? Is that
Yeah,
just negligence or?
yes, exactly. He just basically ignored the fact that there is a web form and made his decision based on whatever was uploaded to the portal. Yeah, unfortunately, this is scary too.
Well, it's just crazy because if you think of the system, like this person, okay, she made a mistake like a lot of people do, fixed it right, it sounds like fixed it right away, like within a few days by submitting the extra documents. Now this agent goes to process, totally ignores some of the documents. The problem I have, obviously IRCC is not perfect, right? No government entity is. I wish they were a little bit closer to perfect. But anyways, this processing agent rejects it incorrectly. What does this mean? Now, the aspiring immigrant is freaking out to begin with, right? Extremely dramatic situation. They might have to submit a web form for a reconsideration request. They might request GCMS notes, and they end up JRing. And so what does it do? It costs them all this money, all these government resources as well, right? Which are already overflowing
Yeah.
just because of one little mistake at the processing stage, right? If that agent just approved it, all those other government resources were not required, all the extra stress and money. So that's probably my biggest gripe, right? I don't know. Do either of the two of you agree? Like my biggest, I understand no government entity is going to be perfect, but my problem is there seems to be so much of those mistakes being made. And then it's a vicious cycle of when you make one mistake, now it takes up even more government resources to then rectify the mistake that never should have been made in the first place, right? So it's like
Absolutely.
a vicious cycle of more delays and funding.
And I
Yeah.
think it just indicates a larger problem with the whole web form system as well. There always seems to be delays with them getting the web forms. They're not, received in the correct order, or they just ignore it, like it seems to be in this case. It'd be nice if IRCC could figure out a better system for us to communicate with them and vice versa. I think that would help address a lot of these issues for sure.
Amen to that. Yeah, I think
Yeah.
every immigration professional and applicant would probably agree. This has been very helpful. I really appreciate the two of you coming on the show, talking about Francophone mobility, which I find to be an interesting and opportunistic program as well, as
Hmm.
we talked about, especially for strategic-minded employers. GTS, which is great for, an important tech industry, and then JR, which can be a good option at the right situation for the right applicants. Maybe my last question for either or both of you, anything you want to highlight, any last tip or piece of advice you might want to give to either an aspiring applicant or a Canadian employer, something to, and end on maybe a more positive note on or piece of advice?
A positive note. I was going to say, like you mentioned, there's so many policies and new changes to the regulations on it seems like almost a daily basis. It's so hard to keep track of everything. But definitely, seek help when you can, if you're able to, by using a representative, preferably a immigration law firm like us. We would just make the process a lot easier because this is what we do day in and day out, and we're trained to pick out on all those little but very important key requirements and eligibility factors. But again, if you are submitting an application by yourself, please go and look at the operational manual and guidelines that's available online. You have the regular program requirements on the main websites, say, for example, OINP or Express Entry. But if you look at the operational manual, it goes into very specific details, which might help you avoid a refusal because you're going to make sure that you're actually, submitting all the proper documents. But then again, that gets a little time intensive as well. That's why I was saying also consider using a representative for your application. But that would be my tip.
Awesome. That's great advice. And then I'll ask as well, either Rema, if you have your own answer to the question, and or if people do want to take you up on that offer and maybe get in touch, learn more about the firm or talk to either or both of you, where do you recommend that they go?
They can reach out to us and go to our website and submit a web form. Then we will reach out right away after receiving the web form.
Your
Also,
web
we are,
forms are faster than IRCC, I guess, the
yes,
responses.
it is.
Yeah.
Definitely. We will respond in less than 24 hours.
I wouldn't call it a web form. You're just going to give people,
Contact
if people
form.
are going to freak out, right? The aspiring immigrants are going to freak out thinking they have a new web form to deal with. Just kidding,
Available.
right?
Yeah, we're
And
also
we'll,
on LinkedIn
yeah.
as well. Facebook, Instagram, TikTok. I think we're covered on most platforms.
On all the socials. That's awesome. And we will include links to both the website and a couple of the socials and probably LinkedIn profiles for both of you as well if people want to get in touch. Whether you're watching this on YouTube or listening on your favorite podcast platform, just check the description below and you'll find the links right there. Rebecca, Rema, thank you both again for
Thank
coming
you,
on the show. I really
Josh.
appreciate
Thank you
it.
for having us for the
Thanks,
day.
Josh.